Okay, guys, I'm doing these videos for basically finals, but it's going to be basically my going through everything else for the rest of the semester as well. I'm going to focus all the new videos on chapters 1 through 4, and I think I'm going to do about 8 of them in about 45-minute clips. One will be right now the sources of law, then I'll do the constitutional history and the ratification process, then I'll do one for amendments and clauses, the Texas court system versus the federal court system, the terms, 5 phases of litigation, and filling up that civil versus civil versus criminal charts is another one, and then the types of contracts, elements of contracts, and agency law. I'm going to leave out discharge and damages portion of contract law that I think you can read on your own. We'll go over a couple of the R words during elements, but that's about it. That'll be a read on your own. Everything else from chapter 5 on you will have. I may rename some of the videos to make it a little bit better for you to understand what's going on in them. But I'm going to try to get these 8 videos, 45 minutes each roughly, done within by Tuesday, no later than Tuesday. Hopefully, some tonight, some tomorrow, and then Tuesday morning will probably be my final ones. Anyway, let's go ahead and get started with chapter 1. If you look on chapter 1, your study guide, page 1 of the study guide, it says law is a collection of rules and regulations that determine how the government will treat its citizens and how the citizens will treat its government as well. Now remember, you also need to know Black's Law, the definition of Black's Law, which is in your book as well. And going over that, that was on page, I think, 2 of your actual book. Black's Law defined, it's actually on page 1. Law that is which is laid down, ordained, or established. A rule or method according to which phenomena or action coexist and follow each other. That which must be obeyed and followed by its citizens, subject to sanctions or legal consequences, is the law. So you have that one at the very bottom of page 1 of your actual book, and then a few sentences above it is the one that's actually in your study guide. He does have Black's Law. If you didn't have it on your first exam, it's also one that comes on the final, and people think it's the law in the study guide. It's not the one in the study guide, but rather the bottom of page 1 of your actual textbook. Okay, knowing that the law and the collection of rules and regulations determine how the government's going to treat its citizens, how the citizens are going to treat the government, as well as how they're going to interact with one another. Without enforcement, the law is useless. Enforcement leads to predictability, uniformity, stability over time. And you also have this term called stare decisis that we'll get into a little bit later that deals with those same predictability, uniformity over time when it comes to common law interpretation. Remember, common law is just judge-made law, something be something. We'll talk about that a little bit in a little while. All right, there are 5 sources of law. The main source, the primary source, is going to be the U.S. Constitution. We'll talk about that in another video when we get through chapter 1. Okay, but the other sources of law, and remember, Constitution is the supreme law of the land, comes from the U.S. Constitution, supreme law of the land, most important, and everything like that. But then you have statutory law, you have executive law, you have common law, and then you have administrative agency law or administrative agency law rules and regulations. That's much more chapter 6. So you just need to know basically as a source of law and how it kind of conflicts a little bit with the 10th Amendment. Other than that, I don't think you need to know administrative agencies until chapter 6. All right. So the first one you have is statutory law. Statutory law is when a legislative branch makes a law, whether that be state or federal. If it's federal, that's the U.S. Congress passes a law, statutes, and that's going to be found in Article 1 of the Constitution on how they're going to do that. And if you look at statutory law, each house, Senate and House of Representatives, each of the bipartisan things must pass a bill in identical language, simple majority. Once they've done that, they send it to the president to have it signed. Now, if it gets signed, that statutory law becomes the law of the land, okay, legislative made law. Anything dealing with an act is going to be statutory law. And if you look in your finals packet, there are going to be a list of all the cases in one of the packets, and then probably all the acts that have been on your exam, whether it be Taft-Hartley, Civil Rights Act, whatever act we're talking about. If you had an act on your exam, there's a list of what they are in one of the packets, and then all the common law cases that are tier 1, tier 2 are on another packet. I think I separated them, so one's in packet 1, one's in packet 2, along with 30 questions on each of those as well. But understand, if it's dealing with an act, i.e. Congress makes a law, if it is signed by the president, it becomes law. If it's not, if it's vetoed, which the president has a right to, Congress has the ability to override the veto with a simple majority of 2/3, not just simple majority, but 2/3 of each of the memberships of both houses. If it does, then it becomes a law without the president's signature. Now, we saw this presidential veto with Truman as well. Remember, Truman didn't like the Slave Labor Act or Taft-Hartley Act from Chapter 8. So just note that that would have taken a 2/3 majority of both houses to override, of which they did with the Taft-Hartley Act. All right, executive law. Now, executive law is done by executive order. Now, for finals, you remember we've had a few executive orders. Trump and Obama were huge into a lot of executive orders early on in their presidency. That has been a question that, or a multiple choice answer that you need to know, which kind of makes all of the above a really good answer on storyline scenario dealing with executive orders. Other executive orders: Nixon created the EPA through an executive order, making it independent executive, a combination of both. Clinton's executive order making sexual preferences under federal law, federal protected. The executive order by Truman to integrate the military. Truman's executive order to seize the mill in the Youngstown Steel and Tube versus Sawyer case, which was later overturned as well. Those are all examples of executive orders. I would note all those executive orders for the final. And once again, note, remember, Trump, Obama had a huge amount at the very beginning as well. All right. Now, that is the way the president or the executive branch creates law. Now, how can it influence law? Well, obviously through the creation of executive order, but it can influence it with the appointment of federal judges, i.e. federal judges are appointed by the president so long as they're confirmed by the Senate. They'll serve life terms typically, at least the constitutional courts. The president is going to control the overseeing of executive or dependent administrative agencies and bureaus by overseeing their spending and appointing the leaders, heads of those administrative agencies as well. The appointment of federal judges, like I said before, and the ability to veto any legislation made by the Congress if they don't like it, if they don't sign it. So those are all the way the president can influence the law as well, through the creation of executive order and or control over administrative agencies or executive, appointment of federal judges within the constitutional court systems, presidential veto of an act or something like that, are all ways of doing it. The next one that you have is judicial law or the court system. And when we talk about the court system, we're going to interpret the law, and how we're going to interpret the law is done through the common law system. Now, common law simply means judge-made law. Common law is something v. something. Any of the cases that we've gone over in all the semester, any of those cases would be a common law, judge-made law system that establishes precedent. Now remember, for precedent to be established, it must be a majority opinion of appellate court that is written and published in order for it to establish precedent under the stare decisis. Now, common law requires stare decisis. It also uses judicial review. Let's talk about stare decisis. Stare decisis says we're going to use previously decided cases by the court system, by the appellate court system, to determine setting precedent for future court rulings. And until there's a logical and rational reason for change, those previous court rulings are going to establish precedent for any future ruling. Now, judges are reluctant to change precedent, but it does occur. Because they're reluctant to, these precedents establish uniformity and predictability if you follow precedent being done, until there's a logical and rational reason for doing so. Now, you had maybe on your first exam the difference between judicial activism and judicial passivism, also known as judicial restraint. Now, judicial activism is where the judge, and we're mainly talking about appellate judges really, but when it could be a trial judge as well, but when they follow legislative intent or how the framers of the Constitution would do, that is going to be more judicial passivism. Judicial restraint is another way to say it. When the judges make their own decisions based upon their own political or personal ideology and don't care about the legislative intent, that is much more judicial activism. And you might have had a little question on your first exam about the legislators in black. Legislators in black, meaning the robes, the black robes of the judicial branch, create law through judicial review in the common law system when they're doing everything. Now, the next aspect of judiciary court system is judicial review. Judicial review gives us the first case, that is Marbury versus Madison. This is a tier 1. It is also going to be mainly one of the 8 or 9 cases I've heard about consistently being on the final. And when we talk about the final, remember, it's usually 100 questions, 3 points each. I don't know if it's going to be that way this semester. It may be completely different. You get 50 questions worth 6 points each. Okay, but Marbury versus Madison is a big one. Remember Marbury versus Madison. Marbury was a judge appointed by Adams, Adams being a Federalist. By the time the appointment went through and was going through the process, at that point, Jefferson became the judge. Jefferson, being an anti-Federalist, did not want a Federalist on the court, so he basically took out his appointment and others' appointments as well. Marbury then sued Secretary of State James Madison, later president, founder of the Constitution, and this established judicial review. This is where the Supreme Court looked over the Judiciary Act of 1789 and found that the Judiciary Act, or an act created by Congress, was found unconstitutional. So if you remember the little things about it, Marbury sued for his appointment to go through under Adams, a Federalist. Jefferson had denied his appointment as an anti-Federalist. He sued then Secretary of State James Madison for his appointment. The Supreme Court found the Judiciary Act of 1789 unconstitutional by finding an act by Congress and or the president is unconstitutional is an example of judicial review. Now, judicial review can be overturned. We usually overturn it through constitutional amendment. This is going to be very rare. Texas v. Johnson was a flag burning case in Texas. It came very close to having a term overturned, but freedom of speech with flag burning took precedence over that. So note, Texas v. Johnson also being one of those cases you might want to note. And remember, when you go through and look over, if you looked over your exams for finals and stuff like that before you left, and obviously you can't now, if you took a look at any of the cases that were on the exams, then those are things that you might want to be prepared for also for the final exam as well. All right? So the things under judiciary system that we need to know. We'll talk about civil versus criminal a little bit later on. You need stare decisis. Previously followed cases are going to use precedent or establish precedent. That'd be a majority opinion that is written and published by an appellate court. It'll lead to predictability and uniformity unless a logical and rational reason is needed for change. Now, if the interpretation of the courts is done with their personal or political ideology, that's more judicial activism, legislators in black. Whereas if it's done where they look at the intent of Congress or the intent of the framers of the Constitution would look at that act, then that is going to be done with more judicial restraint, also known as judicial passivism. Marbury versus Madison created judicial review. Judicial review is the power of the courts to declare an act by Congress and or the president is unconstitutional. So it's taking the act by Congress, the legislative branch, or the president, another of the separation of powers, so the other two branches of government, and finding it unconstitutional. It is technically not an example by technical rule for it to be judicial review when they overturn a case. That's just when for example, when Plessy versus Ferguson was overturned by Brown versus Board of Education at Topeka, that would not be technically judicial review because it was a court case being previously changed because of a logical and rational reason for doing so. All right, on page 3 of your study guide, you also have administrative law. That is much more into chapter 6. So just understand that administrative law is a source of law, not a primary source, the primary source being the Constitution. And it has a direct conflict with the 10th Amendment, which is a reserved powers clause that says anything not expressly granted to the federal government, usually under Article 1, Section 8, all the enumerated powers, shall be reserved to the states under the 10th Amendment. Well, the administrative agencies, the delegation of authority wasn't really given to them directly, and so the 10th Amendment, it kind of differ a little bit. So note that as well. Now, the next things on the Chapter 1 information you need to know is really some terms. And if you have some questions from Chapter 1, it's usually going to be, is this a public or private? Is this a legal or equitable? Is this civil versus criminal? Is this federal versus state? All those things. So those are the ones that come in from here. Now, federal law includes Constitution, federal administrative agencies, congressional actions, presidential executive orders. All that stuff falls under federal law. State law is going to be state courts, state legislative, state regulatory agencies, city ordinances, county governments. Okay? And state law varies from state to state. Most states that adopt a similar law, that is the majority rule. When a rule is a trend or very few states do it, it is a minority rule. Now that comes more into chapter 4, but no, majority versus minority. Other times is when there is no national law, the states will create a law, the national government will look it over to see how they want to maybe modify a law or allow things to occur. So something may be illegal at the federal level, but the states are allowed to do it. Rather than just saying blatantly, you can't do it, states, because it violates federal law, they're seeing how it goes. An example of this is illegal use of marijuana. In the federal government system, it's illegal to use marijuana, but you have states like Colorado, Alaska, Maine, California, various states, more and more states becoming to where legalized in that state to use marijuana in certain conditions and stuff like that. Well, if it violates federal law, you still could be in trouble federally, but you would not be violating state law. But do you want to have federal enforcement of these laws? No, the federal government's looking to see if these state laws carry more weight. Maybe we change the law at the federal level. All right, on page 4 of your study guide, and that's where we talk about majority and minority rule at the very top there for testing grounds. Then you have a couple other terms, public versus private. Now, if you remember this for nuisance in chapter 5, nuisance and unreasonable interference with the use or enjoyment of your land, public versus private really is how many people are affected. For chapter 1, sources of law, public versus private is different. Public means the government is going to be involved. And if you're in 211, that would be like, fair trade versus free trade. Private is going to be individuals or businesses. Government is not involved. So if it's going to be the government, i.e. criminal actions are going to be also a matter of public law because the government gets involved. When you commit a crime like robbery, rape, murder, capital murder, say you get a storyline on capital murder, that is going to be public because the government is going to be acting as a prosecutor. If you want to sue someone for the tort of wrongful death, the tort, that would be more individual versus individual. So say someone committed a crime. The prosecutor is going to do that under criminal law. That is going to be done by the state, and it's going to be more public because the government is involved. If you win that case and they get sued, or then you want to sue them for tort of wrongful death or kidnapping, the tort of false imprisonment, all those different things, the crime would be public, but the actual tort would be private because the government is not involved in those. That is much more individual versus individual. It could be business versus business or individual versus business, okay? But it has nothing to do with the number of people for public versus private in chapter 1. It only deals with did the government involved or not involved. Now, civil versus criminal. We're going to make a little chart real quick at the very end here. Civil versus criminal. Criminal law is going to prevent crime. Civil law is going to, the primary purpose is reimbursement. We're about to do a chart that's in your packet. I think it might already be filled out. I'm going to check real quick. But understand that an action can be both civil and criminal. The crime of murder, the tort of wrongful death. The crime of kidnapping, the tort of false imprisonment. Okay? So the crime of assault would be the tort of battery, technically. All the different things as well. We'll talk about burden of proof as well, but then you have substantive versus procedural law at the very end of chapter, page 4 of your study guide. Substantive is your rights and duties. It's the content, the meat, the real heart of the law involved. Procedural is how we're going to do certain things. If it takes 10 steps to for somebody to be appeal or something like that, or 10 steps in terms of procedural for enforcement of their rights, that is going to be much more procedural law, okay? So note that. Then we have equitable versus legal. If you remember equitable is the original English version. It is non-money. It is to avoid unjust results strictly from common law where money will not suffice. When legal remedies are not sufficient. Legal remedies are money. Money would be a legal remedy, okay? Equitable remedies could be reformation from chapter 4, rescission from chapter 4, an injunction which you could have in any of the chapters as well. Those are all examples of equitable remedy, non-money English variation. Then you have legal remedies. Legal remedies are going to be money. That could be compensatory damages, punitive damages, consequential damages, liquidated damages, any kind of monetary reward or damages are going to be legal remedies. Can you ask for one or the other or both? Absolutely. It gives you a storyline and says you want someone to pay you. So say some action occurs and you want to be reimbursed $50,000. You're asking for a legal remedy. If someone took your antique and you don't care about the value, you don't want $50,000 for the antique, you want the antique back, you're asking for more of an equitable relief because you want the item back. Whereas legal relief, you'd be asking for the money. All right, let me get one quick thing real quick, and then we're going to continue with the civil versus criminal chart, and then we'll be done with chapter 1. Okay, sorry I had to get this. I forgot to get my packet. Real quick, this is going to be the last thing on this little short video that we're going to do. Is in the back of your red packet, which is part 1, you have your court system chart, which will probably be video 3. And then you have before that a list of all the executive orders. We did all those executive orders. I don't think I talked about LBJ's. It created affirmative action program for race, but I think I went over all the other ones that are listed on that executive order sheet. We're going to quickly go through civil versus criminal. In civil versus criminal, you already have this chart filled in. We're just going to talk about it briefly. This is the beginning of chapter 3. So instead of redoing chapter 3, we can start into Texas court systems right away by doing this one now. Criminal is going to be exclusively statutory law only, whereas civil is a combination of statutory and common law combined. The reason why we have criminal law is to punish the wrongdoer for what they did. Civil, we're trying to get reimbursed, either through an equitable remedy, but more than likely a legal remedy for the reimbursement. But we're asking for a reimbursement when we talk about civil law. The guilt is going to be beyond a reasonable doubt in criminal. And then for civil, it's preponderance of the evidence. Also known, if you looked in parentheses right there, more likely than not. It's basically a 51-49 that can be swayed civilly, but for criminal, it's got to be pretty much unanimous when we talk about reasonable doubt. Criminal law does receive self-incrimination, Fifth Amendment self-incrimination protection. You do not have to testify against yourself. That is a Fifth Amendment protection. We'll talk about Fifth Amendment when we talk about eminent domain and due process, but this also falls under the Fifth Amendment as well. Civil law, you do not get self-incrimination protection. So if you think about it in terms of the O.J. Simpson case, O.J. Simpson for the crime of murder didn't have to testify and get on the stand because he had self-incrimination protection under the Fifth Amendment. Whereas for the tort of wrongful death, where he's found guilty, preponderance of the evidence more likely than not, he was not able to refuse to take the stand. He had no self-incrimination protection. In criminal law, if you cannot afford one, you can get a court-appointed attorney. Remember the court-appointed attorney case, the FTC versus Superior Court trial lawyers, where they boycotted horizontal price fixing in Chapter 7. That was court-appointed attorneys, but yes, you can get them in criminal. Civil, no. You do not get a court-appointed attorney in civil matters. You may need an attorney, but you do not get a court-appointed one. In criminal, the case type is going to be the people or state versus usually an individual. It may be a business, but it's usually going to be an individual. Whereas in a civil law, it's individual versus individual, business versus business, or business versus individual. And very rarely it might be an individual or business versus the government, but that's going to be more rare. Criminal law is going to be public because it's involving the state or the government itself, whereas civil is much more private, although you could have public if you're suing the government, but for the most part, private. Damages under criminal law is going to be jail or fines, whereas under civil, it's going to be legal or equitable. We just went over legal being money, equitable being non-money. And then for Chapter 7, I just wrote in a little extra one for Chapter 7. Remember, criminal is going to be under the DOJ, Sherman Act, and then civil is the Clayton, mainly FTC under Clayton. There is some DOJ as well. So the DOJ is the only one that does criminal law in Chapter 7, whereas civil law is mainly FTC, but could be DOJ also under the Sherman Act as well. So that's done with Chapter 1. Each of these videos is probably going to be about 45 minutes or so. Some are going to be a little less. Some are going to be a little longer, but we've now done chapter 1. The next video should be the history of the Constitution ratification process. I may throw a bunch of the different states in there as well for y'all to peruse over all the different states. We'll see you in a bit.